My Lord, I was about to look at paragraph 131 of the judgment, which is at page 103 of the bundle, page 105 of the PDF, where the learned judge goes on to say, I'm sorry, paragraph 131, we've looked at 130. In my judgment, that supplies the answer to Mr. Short's point. There could not be an error in the language of Rule C.2 because it deliberately reproduced the language of the existing staff pension scheme, albeit not the executive pension scheme. And pausing there, in my submission, that reasoning is unsustainable. The documents read as a whole contain the clearest statements that benefits will replicate the previous rules, the BAS six continents rules. And in those circumstances, they cannot be treated as supporting the notion that rather than replicate those documents, the intention was to replicate the benefits described in the summary where they are different. That gives primacy to the summary when the documents expressly say that it is the deed that will have primacy, and expressly say that the deed will replicate, in terms, the earlier provisions. This simply does not provide a strong case that something has gone wrong with the language. Someone who was charged with providing rules that replicate the earlier deed provided rules that replicated the earlier deed. And it simply can't be suggested that something has gone wrong with the language in the sense that term is used in Chartbrook and elsewhere. I'll come back at the end of these submissions to deal with how ICS and Chartbrook and Bernardo's and Rainy Sky fit together. Now, I accept I don't gain the same positive assistance from the executive scheme because these terms, or the particular terms, don't appear there. But the same disclaimer was provided. It's at page 266 of the PDF, the letter to the members of the executive scheme, although I don't propose to go there. But what's more, there's no equivalent provision. Because there's no equivalent provision in the executive scheme, it's not a very good, it can't be used as a guide to what that provision means. I made the tail wagging the dog submission, which the learned judge recognised, although did not accept. But finally, I make the point that here we are dealing only with construction. This is not about other arguments that could be raised by members of the executive scheme. It doesn't deal with questions of estoppel, although even putting the disclaimer to one side, it may be that members of the executive scheme would find it very difficult to show that they were worse off by moving, bearing in mind the various benefits they secured by moving to the new scheme, not least that they would continue to see their benefits linked to their final salaries rather than simply relying on statutory protection. So, my Lord, I say these pre-deed documents do not provide any, and certainly no substantial support for the higher or lower construction, and certainly they do not suggest that there has been an error in the language chosen. The other documents relied upon are the contents of the transfer deeds themselves. These are deeds that appear in the supplementary bundle at tab 5, page 148, PDF 151, and tab 6, pages 166 or 169 in relation to the executive scheme. But my first point in relation sees from the first page of the text itself, which is at page 150 of the bundle, 153 of the PDF, they're dated the 27th of March 2003. Now, I accept, of course, that where two documents are signed at the same time, one immediately after the other, the fact that the second one postdates the first by moments doesn't mean that it can't be taken into account. They are both part of the same transaction in that sense. Here, the dates are just too far apart to be treated in the same way. And although they are part of the same overarching business project, they aren't part of the same transaction in the sense that's used in the cases. My learned friend has referred to the Cherry Tree Investments case. That's at tab 20 of the bundle of authorities, and it's an extract from Lady Justice Arden's judgment. I think she was dissenting as to the result, but that's not relevant here. And at page 444, paragraph 80, she says, there is no doubt a well-established principle under which, as the judge held, documents constituting a single transaction are read and construed as one document. Lord Justice Lewison most helpfully explains this rule in his work, Interpretation of Contracts. I need take only one of the authorities to which he refers, namely Smith and Chadwick, 1882, where the Master of the Rolls said the doctrine as to contemporaneous documents rests on this, that when documents are actually contemporaneous, that is, two deeds executed at the same moment, a very common case, or within so short an interval that having regard to the nature of the transaction, the court comes to the conclusion that the series of deeds represents a single transaction between the same parties. It's then that they are all treated as one deed, and of course one deed between the same parties may be read to show the meaning of the sentence. So pausing there, it avoids the ridiculous situation that where one deed happened to be signed before the other may make a difference when a different approach would have been taken if they'd been signed in a slightly different order. That's not this case. Your Lordships, I hope, were sent separately a case called Keck Gardner against Process Components, which is a decision of the Court of Appeal from 2017, and if I can refer to there was a business arrangement that involved two agreements. It doesn't really matter what they were, but at paragraph 6 of the judgment of Lord Justice Lewison, the PCL agreement was a tripartite agreement between KPTL, PCL and the administrators. The next agreement was the KGL agreement, that's at 10, paragraph 10, parties were KPTL, KGL, under a previous name, the administrators, and 4 named directors. So 3 of the parties are the same, 1's different. 2 of the parties are the same, and then 2 are different, KGL and the directors. And then at paragraph 13, Lord Justice Lewison says, one question then is whether the 2 agreements can or should be read together. KGL agreement was made some 10 days after the PCL agreement. The general rule is that subsequent conduct of the parties to an agreement cannot affect the true interpretation of the agreement. Still less can subsequent conduct of strangers to the agreement. Where there are contemporaneous contracts made between the same parties, which form part of a single composite transaction between the same parties, then the several documents can be read together, Smith and Chadwick. That is not this case. Mr. Mill, whose counsel did not contend otherwise, did not suggest the 2 agreements could be read together as what he called a suite of documents. And I suggest that is the position here. We have several months between the documents, and they are not between the same parties, in that the transfer deeds include the 6 continents trustees and 6 continents PLC. My Lord, it may be that doesn't make much difference, because I say the transfer deeds don't take the second respondent very far anyway. What's relied on in particular is at page 156 of the PDF, page 153 of the bundle.
Is this supplemental bundle?
My Lord, yes, the supplemental bundle. I should have said page 153 of the supplementary bundle. It's tab 5 of that supplemental bundle. Under discretionary practices, Rule 7, and it says Britvic principal employer and the Britvic trustee intend to continue under the Britvic plan the following discretionary practices operated by 6 continents PLC and 6 continents trustee on the same basis, something about early retirement, and then increases to pensions in excess of the GMP in payment of 2/3 of the increase in the retail prices index over 5%. But all that does is set out the intention at that time. It showed what they intended to do, although in fact there had been no call for that since the very early 1990s, because inflation hadn't been over 5% for more than 10 years. And all that this does is show that the power was intended at that time to be operated in a particular way in the future. It does not provide any basis for limiting the scope of that power if circumstances change. And that is, in my submission, as far as that passage takes anyone. Before I leave this document, I should go to page 151, page 154 of the PDF. And your lordships will see that transferred members is defined at the bottom of that page, which is, and it's defined as being those beneficiaries under the 6 continents plan who are A, active members who consent to the transfer to the Britvic plan of their benefits accrued in respect of service before the 1st of April, and B, those deferred members, pensioners and other beneficiaries who the principal employer and Britvic principal employer have agreed are to be transferred members and to whom the 6 continents trustee has given notice of the proposed transfer of their benefits, providing that the following will not in any event be transferred. So that they were certainly given notice. I do not understand that we have in this bundle any copies of that notice. I'm not sure that it was either in the original bundle, as far as we've been able to check over lunchtime. I'm not suggesting that's comprehensive, but I don't believe there's anything in the papers before your lordships that deals with that notice. Now, that's the factual background that's relied upon as establishing the meaning of this clause is any higher rate. The legislative context, the final point dealt with in the respondent's notice, concerns the operation of section 51 of the Pensions Act 1995. Now, this was the third piece of legislation that was intended to provide for increases to pension in excess of guaranteed minimum pension. There were earlier provisions in the Social Security Act 1990 and the Pension Schemes Act 1993, which provided for increases but were not brought into force, or not materially brought into force. One difference between those earlier regimes and the 1995 Act was that the earlier regimes would have required schemes to adopt the statutory regime, which in practice meant 5% LPI, measuring LPI on the 30th of September each year, which is what the Secretary of State did. And that was referred to as the appropriate percentage. And that, in my submission, was plainly seen as being unnecessarily prescriptive and intrusive, as many schemes already made provision for increases of this size, albeit using different calculation dates. And so one difference in the 95 regime was that there was an exception from the statutory regime, in particular exception from the statutory calculation dates, statutory timetable, where the scheme was paying 5% LPI but using its own calculation date. And that was called the relevant percentage. And if a scheme ceased to provide that relevant percentage increase, it ceased to benefit from the exception and it needed to adopt the statutory calculations. That's the fact. And the issue between my learned friends and I is whether that protection or that exception was lost where there was an unused power to depart from the relevant percentage. And this turns on section 51(3) of the Pensions Act 1995, which your lordships have. This is at the material time to the 2003 deed. And that's at, I'm sorry, I'm going to go to the material time to the 1996 deed. It may be that it makes no difference, but tab 35 of the bundle of authorities, which is at page 747, this is as at the 5th of April 1997, when the provisions first came into force. And what they provided for was section 51 required the annual rate of pension to be increased by the appropriate percentage. Section 51(3), or sorry, subsection 51(2) deals with the increase being applied annually by at least the appropriate percentage. Subsection 51(3) says, subsection 2 does not apply to a pension under an occupational pension scheme if the rules of the scheme require A, the annual rate of pension, or B, if any part of the pension is attributable to pensionable service on or after the appointed day, that's 6th of April 1997, so much of the annual rate as is attributable to that part, to be increased at intervals of not more than 12 months by at least the relevant percentage, and the scheme complies with any prescribed requirements. So, I've rather garbled that, but the question is whether the rules of the scheme require the pension to be increased at the relevant percentage. And there are references in my learned friend Skeleton that says that it requires that the scheme contains a rule. And that's not quite right, because the subsection requires the rules to provide something. And that's not used in any technical sense. Rules isn't a defined term. It simply means the governing provisions as they are at that time. And until and unless the power was exercised here, the governing provisions did provide for pensions to be increased at the relevant percentage. And an unused power to depart from that practice would really mean that this provision was of little use, because almost any scheme will have a power of amendment which would have allowed it to depart from an existing rule. And more importantly, perhaps, very many schemes have all sorts of powers permitting other indices to be chosen, which would, or at least could, have involved choosing a scheme, choosing an index that did not provide for the relevant percentage. If in 1997 someone had chosen what was then the brand new CPI, it would not have satisfied the statute because it would have been below the relevant percentage. But that wouldn't have lost someone the protection of subsection 51(3) unless and until that was done. And one way to test this proposition is to ask why 5% LPI was paid for so many years, and the answer to that is because that was what was required by the rules, the power not having been exercised to allow any other sum to be paid. Now, finally, what I say here is that this is such an esoteric point that it's not one of general concern, and it really doesn't shed very much light on the intention of the draftsman in 1996 or 2003. So there's no basis upon which to use these provisions as requiring a conclusion that either the words mean something other than any other rate, and certainly not to suggest there had been any error in the language chosen.
Can I ask you, Mr. Short, do you accept that if you're wrong on that point, Mr. Bryant's right on that point, the practical effect was that unless the employer provided any other rate, trustees would have to increase it by the greater of each year, the RPI increase in May and the RPI increase in September?
No, not necessarily, because there would be a running total which it would depend upon the particular outcome whether that would have to be done.
Why do you say that? Because I understand that for revaluation purposes, you do a single revaluation over the whole period of the firm. But for Section 51 purposes, you do annual increases each year, which is important because the pension is actually in payment, and that's what the pensioner actually gets. So if in year one, the September RPI is higher, that has to be paid, subject to the power of the employer to specify anything else. Because that's what the rule says. And then in year two, if the May one is higher, you take the existing pension as increased in year one, then you have to increase it by the May RPI if it's higher.
Yes, but the change may be different depending on when the calculation is done. I think there, although you can have quite a complex interrelationship between the two figures, it won't always follow that it will be the greater of the two. It may require exceptional circumstances. So if there's a negative RPI in one period, that may have a different impact. So that you don't necessarily get the greater of the two every year. But it would have a particularly inflationary consequence.
Well, a sort of ratcheting effect. Because you
would have, yes. But in my submission, that's a good reason not to adopt that as a matter of statutory construction, rather than to alter the plain meaning of the words here, because it would also apply to every case in my submission that had a right to select another index.
Yes, I see that. You also said this was a rather esoteric point and you want to thought the draftsman would have it in mind.
Yes.
I was going to ask you about that. The 96 deed is put in place just before the 95 Act comes into force.
Yes.
And we've seen now that the previous pensions increase rule provided 4% LPI. So there's been a conscious decision to change either the minimum or the default, depending on who's right, the 5% LPI. It seems a coincidence if that's not done with a view to complying with the statutory requirements which are about to come into force.
Oh, no, my lord, I'm not suggesting it wasn't done with one eye on Section 51, although there had been provisions on the statute book that referred to 5% LPI, I think, since
the Social Security Act 1990.
But so it may well be done. What I say is esoteric isn't the introduction of 5% LPI on benefits from the 6th of April 1997 onwards. What is esoteric is the suggestion that the ratcheting effect might be brought into play where there is a power to change a rate or an index so that it is no longer the relevant percentage.
I see. I mean, I think the inference one might draw from the way it's put in place in 96 is that the draftsman did intend the 5% LPI to be a relevant percentage, and so to disapply the statutory percentage.
Well, when it was introduced in 1996, none of the benefits at all were going to be protected.
But you could see it was already known by then this was going to come into force by April 97.
Yes, it was. I think the statutory instrument had already been published, bringing it into effect. So that was known. But what was also known is that none of the benefits that existed at the time of the 1996 BAS deed were subject to these rules. these statutory rules.
Yes. Okay, thank you.
Now, attempting to pull these submissions together, my starting point is that the language is not ambiguous. On that basis, in accordance with what Lord Clark says in Rainy Sky, that is it, save, and I can make this as a concession, save where there is something that has gone wrong with the language. And I say that a mistake has been made. And in my submission, it's tolerably clear that Lord Clark was not seeking to deal with those cases because Rainy Sky was an ambiguity case. And Lord Clark does not suggest that, for example, Manai was wrong. Now, Manai is a case where 12 meant 13, or vice versa, the 12th and the 13th. And that is obviously not ambiguous. That was held to be a mistake that was corrected. And Lord Clark does not suggest that is wrong. So that's why I say it's clear that he meant construction of the words used rather than cases where one is effectively changing those words in recognition of a mistake. And that is easiest in cases of numbers, decimal points, maybe a knot missing. One can imagine many circumstances where that is clear.
Or you sometimes get this description, landlord for tenant, tenant for landlord.
That's right. Or in one of the old cases, a particular pub was misnamed the Bricklayers when it was the Watermans, or vice versa. And it was clear, because there was only one pub, and it was called the Bricklayers, not the Waterman, or vice versa. It was clear what was meant. And that wasn't a matter of construing the language. It was a matter of identifying that mistake and correcting the language. Now, there is a further question as to whether the mistakes must be limited to the four corners of the document. And in my submission, that's one that, again, is not dealt with in Rainy Sky, but it's, in my submission, possible to look, that the weighted authority says it isn't limited to the four corners of the document, and even looking at some of those examples, it was only possible to know whether the Waterman's Arms or the Bricklayer's Arms was the correct in the old case, by going to Southwark or wherever it was and seeing what the pub was called. But that, I say, isn't contentious, isn't dealt with by Rainy Sky. That also preserves a role for ICS, the fourth and fifth principles of Lord Hoffman, and it is consistent with the approach taken in Bernardo's by Lord Hodge. And in my submission, that is the only way to bring those cases together. It's the only way in which they are all still correct. And given that they have not held each other to be wrong, and in particular, there is no suggestion that Lord Clark was wrong in Rainy Sky in the three subsequent decisions of the Supreme Court. That, I say, is the best way in which to synthesise the four, or the entire line of cases. It doesn't particularly matter whether it is seen as a separate task, a separate act to the unitary act of construction, or a particular element of it, and I accept the weight of authority is probably that it is part of the unitary act of construction, but it is an identifiable subcategory or an identifiable element of the unitary act of construction, which is necessary in order to allow the clear words of Rainy Sky to be departed from.
Well, how does that sit with Lord Hoffman's fifth principle in ICS, which endorsed the entire detailed semantic and syntactical analysis of words in a commercial contract is going to lead to a conclusion that flouts business common sense? It must be made to yield business common sense.
But because it's on the basis that it has to be so extraordinary that they can be clear, the court can be clear that it was a mistake. That is the, not that it was a bad deal, not that it was an unfair deal, but simply flouts common sense to the extent that it must be a linguistic mistake. Otherwise, one is faced with an obvious tension between these cases, and the last four cases in the Supreme Court have followed Rainy Sky.
Yes, I mean, I completely understand that. I think, if I may say so, whilst you are trying very hard and commendably to fit all these cases together, there is a difference between construing a contract so as to accord with business common sense and construing a contract so as to rectify an errors.
Yes. I accept that. There will be cases when it overlaps, and it may be the business common sense can be identified by the figure that's used being so dramatically out of step as to only be explicable, or there's a very strong case that it's explicable, by there having been a mistake rather than it having been a bad bargain. And it may narrow down very much the scope for the approach taken by Lord Hoffman in ICS, but it retains some of it. Alternatively, I simply rely on Rainy Sky and the cases since then that have all said it's the same thing.
I'm sure that is the best you can do, Mr. Short, in the circumstances of their lordships' prognostications.
Yes, my lord, yes, certainly the best I can do. I know that's a sense of it depends where one puts the emphasis, but those are my submissions. Yes. Of that first point. I'll deal briefly with the other grounds of appeal. Ground two.
Just before you do, presumably as a matter of the doctrine of precedent, we are bound to follow the latest announcement of the Supreme Court.
Yes.
We don't get to pick and choose which ones we like.
My lord, that's right, because the latest ones are binding on you as to what the earlier ones meant.
Yes, even if we thought they might mean something different.
My lord, yes.
Yes. Well, that means you have to do less thinking.
My lord, there we are.
I've always known that masters of the rolls were encouraged not to do too much thinking.
Well, my lord, there we are. I should have just put...
You're not supposed to comment on that, Mr.
My lord, I'm certainly not commenting on that. What I'm commenting on is maybe I should have just put that sentence from Rainy Sky in my skeleton and left everything else. But those are my submissions on the first ground.
Yes, thank you.
The second ground is the question of whether more than one rate can be chosen, other than in relation to pre and post 2008 service, where the rule itself differentiates. I accept that it is expressed in the singular, but I rely on section 61C of the Law of Property Act 1925, whereby the singular includes the plural. That's in Authorities tab 31 at page 713. I'm not sure I need to take your lordships to it, because it really just says that. But this is the approach that was taken in Kinetic, which is at tab 19 at page 414. And that is paragraph 70 and 71. I'm not going to read those two paragraphs out, but I adopt them and say they are applicable, directly applicable here. There may be all sorts of circumstances where it may be sensible to give different rates of increase in relation to different periods, and in some cases that may be of assistance to the members, where the employer may want to give a particular enhancement to a particular group and wouldn't give any enhancement if it was given an all or nothing option. So a provision that's intended to introduce flexibility should be construed in a flexible way by here allowing different rates to be chosen for different periods of service.
Do you have another point, which is, it doesn't say, the rule doesn't say the pensions shall be increased at rate X or Y. It says each pension shall be increased. So just looking at the terms of the rule, you could look at each pension one by one, could you not?
My Lord, yes, we could. We didn't introduce that as a question for the judge, so he hasn't adopted that. The question we put was broader, which was just whether different rates could be applied to different tranches of pension,
yes,
on an individual basis. So, my Lord, yes, I would accept that, but that's not one of the questions we put to the judge, so that's not something that I think that's in this court.
So what is the question you put? Can I just look at the terms of the question you put? Where do I find that?
The amended claim form is at tab 9, page 110 of the core bundle, and it is question 5.2.
I see.
Whether the rule allows different rates future increases for different tranches of service.
Yes, I see. Thank you.
The third question is whether the third ground of appeal deals with the question of whether the employer would need to follow the annual timetable, and so can only make this decision on an annual basis after the trustee has identified the increase that it would apply. In my submission, there would be no good reason for such a technical approach, and there is no reason why the employer shouldn't be able to say 5% LPI for the next 5 years or until further notice, or if it's allowed to impose a lower figure, CPI or 1% under RPI, subject to statutory requirements, until further notice or for the next 3 years or something of that nature. There's no need to read anything in to make it more restrictive. Fourth ground of appeal deals with whether the rate selected could be 0%. The original question asked was at or near 0%, but my only friend Mr. Chu made the point that answering the question of what's near 0% isn't very helpful to the trustees when administering the scheme, and we accept that point. So the question now is whether it can be reduced to 0%. This does require one to look at the rule itself again. I ask your lordships to look at page 140 of tab 13D of the core bundle, page 144 of the PDF. I mentioned this earlier, but Rule 1 does say each pension under the plan increases in each year, which may be thought to be an obstacle to 0%. But as I also submitted, that does not in fact mean that they will increase in each year, because when RPI was 0, the increase was 0. In practical terms, pensions will increase to some extent in most cases, even if a rate of 0% is set, unless RPI is 0, either because members will have some post-97 service, which will be subject to statutory increases, or they'll have some post-1988 guaranteed minimum pensions, which will also be subject to other statutory increases. But really I go back to the underlying proposition, which is subject to the statute, if it's possible to substitute any other rate, that includes a rate of 0%. The final ground of appeal deals with the interaction between the indexation and the revaluation provision in Rule C.2. Rule C.2 is at page 1339 of the bundle of the same tab, page 143 of the PDF, and it deals with deferred pensions. This is for people who leave the plan prior to normal retirement date. And the rule, this is Rule C.2, sub-rule 2 of the staff rules, but the same effective rule is in the executive rules. And it says a staff DB member whose pensionable employment ends before normal retirement date is entitled to deferred annual pension payable from normal retirement date. It is equal to the scale pension increased as from the date pensionable employment ends, as referred to in DB Staff Rule 10.2, C10.2, and 4 pension increases. But the total increase at normal retirement date should not be less than that required by the Pension Schemes Act 1993. So then the question here is whether the cross-reference to Rule C10.2 incorporates the mechanism so that it's increased by 5% LPI or some other rate selected by the employer, or whether it incorporates the output of Rule 10.2 so that the same rate has to be applied across both rules. In my submission, the language could allow either. And so one has to be guided by the courage purposive approach and what is more practical and reasonable, and the flexibility offered by the different approaches in my submission is to be preferred, because revaluation concerns different statutory schemes, and it does a different thing. It deals with the increases in the cost of living between leaving the scheme and normal retirement date. The employer may have all sorts of reasons why it might want to treat people differently in different respects, some of which may be to the benefit of the member. And so, in my submission, a more flexible approach which allows the power to be exercised independently in relation to revaluation should be followed. Now, my Lord, unless I can assist further on those points or any other, those are my submissions. When we put the timetable together, we wondered whether we go much more quickly than this, and I'm conscious that I've taken some of my learned friend Mr. Bryant's time. But unless I can assist further, those are my submissions.
Thank you very much, Mr. Short. Lord Justice Coulson, any questions? Lord Justice Nugee?
No, thank you very much.
Thank you very much. Mr. Bryant?
My Lord, thank you and good afternoon. May I first ask a question, which is, you mentioned first thing this morning that you would plan to take a mid-morning and mid-afternoon break. I'm just wondering when mid-afternoon is likely to fall.
Would you like it, Mr. Bryant, or would you like to poison our minds first before we leave?
I'm entirely in your hands.
Right, let's take it now and we'll come back at 3 o'clock.
Okay.
I think you're muted.
Yeah, we've got Lord Justice Coulson and everybody. So, Mr. Brown, please.
My Lord, thank you. I noted this morning that Mr. Short was referring you to two numbers for each page in the bundle, because the electronic PDF bundle numbering that's gone slightly awry. Unless anybody objects, and if so, please do say so. I'm just going to refer to the large number in the bottom right-hand corner of each page, which hopefully will be sufficient to navigate our way around to the right documents. But please, if anyone is not okay with that, tell me. But by way of brief introduction, my lords, the main focus of this case, as we all know, was and still is a short construction point, albeit a number of subsidiary questions are asked. And it turns on the meaning of Rule C.2 of the Britvic Pension Plan in its various iterations. There are all manner of other issues relating to benefit entitlement under this scheme. They were set out, and I appreciate you don't have this before you, they were set out in some detail in the trustee's skeleton at the first instance hearing, and they will need to be resolved at some stage, as we have made clear a number of times during the course of this litigation. There are also various issues coming to a point made by my Lord Justice Nugee this morning, various issues concerning the predecessor schemes, including the construction of the pension increase rule in the what was the BAS scheme, then became the Six Continents Pension Plan, and is now the Mitchells and Butlers plan. That is the litigation that is ongoing, and in which there is to be a first instance hearing, as I understand it, starting the last week of June, so in a little over a month. I think it's listed for 3 weeks in front of Mr. Justice Trower. My Lord Justice Nugee asked the question this morning, what impact would that case have on this case? I think that was the gist of his question. At the risk of being accused of passing the buck, I think my learned friend Mr. Chu is also instructed in that case. So if you need detail, he is probably in a rather better position than I am to give it to you at some stage, presumably tomorrow. All I would say in addition to that is, if I can invite you to turn to tab 20 in the supplementary bundle. We looked at it with Mr. Short a little earlier today. It's the interim agreement, as I think it's been termed, in 2019, which was then the subject of, by Chief Master, the 1% increase for that particular year issue. And if I can invite you to turn...
Give us a page.
333, please. There are a great number of recitals to this agreement. And if one starts at capital I, it's the second main recital on this page, and then they carry on over the page. I'm not proposing to take you through it, but simply for your note, if you are concerned and wish to know more about what certainly the trustee says about the M&B case and its impact on this case, that may assist. One issue I can raise at this stage is that, as I've said, in the M&B proceedings, as I understand it, be corrected if I'm wrong, there is a construction issue and indeed a rectification issue concerning the 1996 pension increase rule. Is Rule 23, we were taken to it by Mr. Short, and there may well be a potential impact of the outcome of that point in the M&B proceedings, at least for deferreds and pensioners who transferred into the Britvic plan, those who are the subject of the
But Mr. Bryant, it can't possibly, I mean, we can't possibly, can we be concerned about anything that litigation, because we have to decide this case according to the arguments and facts and evidence in the appeal.
Oh, indeed, my lord. I
mean,
agree entirely.
I mean, it may well have an impact. I mean, it sounds as if it's inevitably going to. No doubt our judgments will be poured over by the proponents in their cases and by Mr. Justice Trower. But I mean, we've just got to get on and decide. I mean, you might say, I imagine you do both say, can we have a judgment by that time?
I imagine probably Mr. Chew will be the keenest to have a judgment by then. But yes, I agree entirely, my lord. No, I didn't want to take up time unnecessarily dealing with this point. It was simply at least trying to be helpful and to deal with Lord Justice Nugee's question of this morning. And if I may very briefly just finish the point I was about to make. If one looks at General Rule A4, unless you invite me to, of the Britvic rules in all of the, that is how the predecessor rules will come into play in this scheme for the deferreds and the pensioners. Albeit, your lordship is absolutely right. The outcome of M&B will not of itself give rise to any sort of issue of stock or anything of the sort. Moving on, the next point I was going to make by way of introduction is that we were not suggesting for one moment, and indeed did not suggest below, that the well-established principles of construction do not apply to this case as in any other construction case, be it pensions or otherwise. In light of the discussion between my Lord the Master of the Rolls and Mr. Short this morning, rather begs the question as to what those principles in fact are, and I'll come back to that in a moment if I may. But we do say that whichever of the various options in terms of principles and how they fit together is applied to this case and its somewhat unusual facts, the answer becomes clear. And as the judge found below, that answer, we say, is obviously in favour of our construction of Rule 10.2. And this was recognised by the judge below. It's paragraph 133 of his judgment, tab 7, page 103, where he says, I should stress that my decision is highly sensitive to the facts of the present case. And I'll expand on that in due course.
I mean, but he said that, but it struck me as a rather strange thing to say. I mean, of course, facts are relevant to all cases, but this is a point of contractual interpretation. And, okay, factual matrix has a greater or lesser impact on it and all the other things. But, I mean, to say that it's highly sensitive to the facts, where the Britvic Pension Plan was not addressed to future new members, is giving a massive amount of weight to that point, isn't it?
Well, that's the specific point he mentions in that short paragraph, but there are other particular and unusual features of this case. One, for example, is the nature of the transfer consents and the transfer invitations that I'll come to in due course, perhaps tomorrow, looking at the time. That makes this a factually unusual case, and not what one might call a run-of-the-mill construction of a pension rule in an existing scheme, members, and so on. My Lord, turning to the principles, and thank you for providing us, I'm not entirely sure which route it came through, but with a copy of your article from, I think it was 2017. There is also, as I think my own friend Mr. Short mentioned this morning, there is a Trust Law International article from 2019, which I think from memory comments on both your article and the articles of Lord Hoffman and Lord Sumption. If it will help, we'll attempt by one route or another to provide copies of all of those overnight, and I may need.
That would be helpful. I mean, you know, even if they're not in the end important, it's good to see what people have been saying.
Yes, well, we'll arrange for that to be done, and presumably to your respective clerks is the quickest route.
Yes, if you send them to my clerk, it'll come to it'll go to everybody.
I'm grateful, and I may need to have, well, I will need to have more to think about the safe and ice in light of the articles and the points you were discussing with Mr. Short this morning, and perhaps come back to this. But in very short order, our position on the matters you were discussing with Mr. Short is this. Now, dealing with the rainy sky unambiguous language point, may I invite you to have a look at rainy sky? It's tab 17 in the authorities bundle. It starts at page 351. And Mr. Short referred you to paragraph 23 in the judgment of Lord Clerk, where he says where the parties have used unambiguous language, the court must apply it, and goes on to refer to the co-op, also society, authority, and so on. What I would say is this. One needs to read paragraph 23 in context. And if one looks, for example, at paragraph 21, a couple of paragraphs earlier, Lord Clerk says this: the language used by the parties will often have more than one potential meaning. I would accept the submission made on behalf of the appellants that the exercise of construction is essentially one unitary exercise in which the court must consider the language used and ascertain what a reasonable person, that is, a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract, would have understood the parties to have meant. In doing so, the court must have regard to all the relevant surrounding circumstances. If there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other. In my submission, what that is saying is that one is entitled, the court is entitled to look at all of the admissible evidence, including background material, be it legislative or factual, as part of the exercise in order to determine whether the language used in the instrument in question is in fact unambiguous. So, as part of the unitary exercise, the unitary process of construction, if you will, one looks at all of the admissible material before one can decide whether it is unambiguous. If it is in the light of all the relevant admissible material, if it is concluded that it's unambiguous, then paragraph 23, Lord Clerk, that's it. But if not, then one goes on to look at the other parts of the iterative process. So that
obviously true, Mr. Bryant, in this sense that plainly one does look at the admissible material before you construe an agreement. But the word unambiguous in this context is a textual word. It's talking about whether the words used in the agreement can reasonably be taken by the objective reader to mean one thing or more than one thing. So I mean, you can't, it seems to me he is not saying, is it ambiguous in the sense that somebody has suggested it meant something else at another time. He's saying, is it ambiguous on its face? That's the first question.
Well, my lord, whether wording is ambiguous or unambiguous, we say is not simply a question of looking at the words themselves. One needs to look at the context in which the words are used. The second short point I was going to touch on is the corrective construction issue that again you discussed with my learned friend Mr. Short this morning. But I think in fact from Mr. Short's comments later in his submissions, we're not a million miles or indeed any miles apart on this, I believe. have a look at the articles and relevant materials overnight, but in my submission it is clear that one can look outside the instrument itself to see whether wording included in the instrument involves a mistake, and if so, what it is. That Mr. Short accepted in submissions. That is what was said, albeit, I think, obiter in the Manai case. And another example, which we might hesitate to use, but certainly to summarise, is the judgment of Mr. Justice Nugee, as he then was in the Sterling Insurance case, which is in your authorities bundles, where, in short, as I read it, the court looked at the legislative background to decide whether there had been a mistake in the wording in the rule, and if so, what it was. I think it was adding due to accrued in that case, and the particular background matter that was in play there was Section 67 of the Pensions Act 1995. Whether it is a separate matter or merely one part of a unitary exercise, I agree with Mr. Short's position that it is, or the weight of authority certainly suggests that it is one part of a unitary exercise, and perhaps that's most neatly summarised, I think, by both aspects of this corrective construction point. At in Chartbrook, tab 14 of your authorities bundle, it starts at page 288, and if I can invite you to turn to page 301, that's the bundle numbering rather than the internal numbering. And Lord Hoffman refers to Lord Justice Carnworth's judgment in the KPMG case, which again is also in your bundle, but I won't take you to it unless you ask me to. We have paragraph 23. The first qualification is that correction of mistakes by construction, in quotes, is not a separate branch of the law, a summary version of an action for rectification. As Lord Justice Carnworth said at paragraph 50, both in the judgment and in the arguments before us, was a tendency to deal separately with correction of mistakes and construing the paragraph as it stands, as though they were distinct exercises. In my view, they are simply aspects of the single task of interpreting the agreement in its context, in order to get as close as possible to the meaning which the parties intended. The second qualification concerns the words on the face of the instrument. I agree with Lord Justice Carnworth, paras 44 to 50, that in deciding whether there is a clear mistake, the court is not confined to reading the document without regard to its background or context. As the exercise is part of the single task of interpretation, the background and context must always be taken into consideration. I know you asked Mr. Short to put together a list of relevant cases this morning, and depending on the outcome of that and further researches on our side, as I say, I may need to come back to this, but in short, that's our position. Mr. Short,
just before you leave, Mr. Bryant,
of course.
Do I understand it that your case on this appeal is that this is a case where something has gone wrong with the language, or is that a secondary fallback point? Or how do you put it?
It's a secondary fallback point.
That's the way the judge treated it, and you seek to uphold that.
Yes.
Yes. Thank you.
Yes, we say we don't need to go that far to uphold the judgment, but if we do, we say that this is a prime case for a corrective construction. It's clear, as the judge found as his secondary finding. It's clear it's clear that there was a mistake, and it's clear what the mistake was. We say.
So, Mr. Bryant, you say it's a secondary point, secondary to a matter of pure construction.
My lord, yes. If I may, I'll take things in order in due course, but I hope it'll become clear what our primary and secondary, and indeed, insofar as we need it, tertiary cases on this are. My Lords, Mr. Short took you to what's usually called the trio of Supreme Court cases. I wasn't planning to do so myself. Having said that, may I invite you to turn to Wood and Capita briefly. It's tab 26 of the authorities bundle. This is the third of the three. And page 586, please. It's part of Lord Hodge's judgment, and it starts at paragraph 9 towards the top of the page. As my Lord the Master of the Rolls invited Mr. Shortley this morning, I'm not going to read it out in its entirety. I'll just take you to the edited highlights, as it were, but please, if you'd like me to go into more detail, then I'm sure you'll ask. I'll skip over the comments in paragraph 9 for now, with which I suspect at least one member of this court may not necessarily agree. Paragraph 10, again, nothing particularly controversial, I don't think. The court's task is to ascertain the objective meaning of the language which the parties have chosen to express their agreement. It's long been accepted this is not a literalist exercise focused solely on the parsing of the wording of a particular clause. The court must consider the contract as a whole, and depending on the nature, formality and quality of drafting of the contract, give more or less weight to elements of the wider context in reaching its view as to that objective meaning, perhaps unconsciously preempting his subsequent judgment in Bernardo's case. Paragraph 12, if I may, towards the very bottom of the page. This unitary exercise involves an iterative process by which each suggested interpretation is checked against the provisions of the contract and its commercial consequences are investigated. To my mind, one has to read the language in dispute and the relevant parts of the contract that provide its context. It doesn't matter whether the more detailed analysis commences with the factual background and the implications of rival constructions, or a close examination of the relevant language in the contract, so long as the court balances the indications given by each. Just pausing there, in my submission, that is consistent with our interpretation of rainy sky, viz. One looks at everything, contractual wording, background, admissible background information, before one starts the unitary exercise, including looking at whether the wording is indeed truly ambiguous. And then paragraph 13, I'll just read the initial couple of sentences. Textualism and contextualism are not conflicting paradigms in a battle for exclusive occupation of the field of contractual interpretation. Rather, the lawyer and the judge, when interpreting any contract, can use them as tools to ascertain the objective meaning of the language which the parties have chosen to express their agreement. The extent to which each tool will assist the court in its task will vary according to the circumstances of the particular agreement or agreements. In my submission, if one looks at the judgment of His Honour Judge Hodge QC below, in this case, that is exactly what he has done. His self-directions, as I'll come to in due course, are I might say, exemplary, and his approach is entirely consistent with the principles set out in Wood and Capita and the other cases. He undertakes a unitary exercise, an iterative process using all the interpretative tools available, and as Lord Hodge tells us in paragraph 13, as I've just read out, the extent to which each tool assisted him varied, depended on the particular circumstances of the case he was dealing with. The appellant's approach, by contrast, in my submission, falls exactly into the trap against which Lord Hodge gives warning in Wood and Capita, which is essentially to see this as an exercise of, its text or context. It's essentially either at one extreme or as they characterise our case, the other. And in my submission, that is not this case. That's not the approach the judge took below. And it is an unfair criticism to say otherwise.
Mr. Bryant, I completely see all that, and you know, I've read the words of Capita many times, and I understand, and it's not right to say I don't agree with them, because even if I didn't agree with them, it doesn't matter what I think. What matters is what the Supreme Court thinks about what the law is, and if it says the law is the same as it used to be, then I have to go with that. The law is what they say the law is now, and even if they say it's the same as it used to be, I have to do the best I can with that. But what I'm concerned about is you say that it's not a competition between textualism and contextualism, but here, do you say that the words of the contract are other than clear? I mean, you say they're not clear.
Yes, I do, and I'll come to why in a short while, if I may.
Well, the judge didn't say that. The judge said they were clear, but there are all these reasons why I can, doing the unitary exercise, come to a different conclusion as to what they mean.
I know the particular passage you're referring to, my lord, but in my submission, looked at in its totality, the judgment below follows the unitary exercise set out by the Supreme Court in the various cases, and in fact does not, well, in reality does not accept the suggestion that this is unambiguous language and that's the end of it. It is more a look at the text, yes, look at the context, and in light of the context, as I've said, paragraph 21 of Rainy Sky, in light of all of the available and admissible information, that then provides the foundation for Judge Hodge's conclusions. My lord, again, I know you will have read this umpteen times, so I'll take it briefly. May I take you to the Barnardo's and Buckinghamshire case in the Supreme Court? It's tab 28 in the authorities bundle. Again, Mr. Short took you to this morning, so I'll take it briefly. And again, I'll just deal with the key points, if I may. Paragraph 13 is page 657 in the authorities bundle. Paragraph 13, having referred to the trilogy of cases, Rainy Sky, Arnold and Britain, and Wood and Capita, Lord Hodge, again, says he doesn't need to repeat the guidance from those cases. He then goes on to say this: in deciding which interpretative tools will best assist in ascertaining the meaning of an instrument and the weight to be given to each of the relevant interpretative tools, the court must have regard to the nature and circumstances of the particular instrument. So that's all of a piece with his earlier comments in Wood and Capita. Everything is to be taken into account, and which tools should be used to which effect in terms of weight is a matter for the particular circumstances of each case. He then goes on at paragraph 14 to set out his 5 distinctive characteristics, as he puts it, of pension schemes. A pension scheme, such as the one in issue on this appeal, has several distinctive characteristics which are relevant to the court's selection of the appropriate interpretative tools. Now, just pausing there, putting that together with the last passage in paragraph 13, that is not saying that, as I understood my learned friend Mr. Short to be saying this morning, whether or not all of these characteristics are present in respect of a particular pension scheme, all of this guidance nevertheless has to be followed, i.e. you have to give more weight to the text than to the background facts and so on. In fact, it's abundantly clear in my submission that each case depends on the nature and circumstances of the particular instrument. And so whether or not all of the various features that are set out in paragraph 14 are present is something that the court is entitled to and indeed must take into account when deciding which interpretative tools to wield and the weight to be given to each of them. And as you know, it was our case below and is our case here that numbers 4 and 5 essentially do not feature at all in this case because of what I say are its unusual circumstances.
Are you going to come back to that point? Or?
My Lord, in terms of the specifics, yes.
Yes.
Yes, I'm going to come to that in a short while. I'm just going to touch on that.
I assume so. Thank you.
Paragraph 15, just want to read the first sentence, part of the first sentence. Having set out the 5 distinctive characteristics of pension schemes, such as the one in issue in this appeal, in Bernardo's, he says this: judges have recognised that these characteristics, i.e. those 5, make it appropriate for the court to give weight to textual analysis by concentrating on the words which the draftsman has chosen to use, and by attaching less weight to the background factual matrix than might be appropriate in certain commercial contracts. So again, it's clear in my submission that Lord Hodge is saying, well, here are 5 particular characteristics that feature in pension schemes such as the one in issue on this appeal. By implication, they may not feature in relation to every pension scheme. And it is these 5 characteristics that make it appropriate for the court to give more weight, as it were, to textual analysis and less weight to the background factual matrix. And in my submission, it cannot, in light of those passages, be said that where those 5 characteristics are not present, as I'll come to in a moment, shifting the balance more towards background material is an error of law as it's characterised by Mr. Short. Paragraph 16, briefly, if I may. The emphasis on textual analysis as an interpretive tool does not derogate from the need both to avoid undue technicality and to have regard to the practical consequences of any construction.
I mean, the problem with jumping from where you stopped to paragraph 16 is that you don't get his endorsement of Lord Briggs's statement that it is therefore a context which is inherently antipathetic to the recognition by way of departure from plain language. So, you know, you don't, he approves that in Safeway.
My Lord, yes. Would you like me to read that passage out?
No, it's not that it's reading it out. It's just that if you jump to 16, so textual analysis is really important. And then he says it doesn't derogate from the need to avoid undue technicality and to have regard to the practical consequences. Well, of course, such an analysis does not involve literalism, but include purpose of construction where appropriate. So, I mean, he's technically got everything available, right?
Yes.
But emphasis on texture.
My Lord, yes, and I'm not suggesting for a moment that the position in this pension scheme case is directly comparable to a different sort of commercial contract, say. But I go back to the point I made earlier. It's a sort of tool belt, as it were, with a number of tools available. Some of them relate to the text, some of them relate to the context, and it's a matter of weighing up in the particular circumstances of each case which ones are of assistance and what weight should be given to each of them. And all I'm suggesting is that insofar as in the Bernardo's case, those 5 particular characteristics were present, and it was in those circumstances appropriate that the balance was tipped more towards the textual analysis than the contextual analysis. In a different case such as this, the balance shifts in the other direction. I'm not suggesting it shifts entirely when one looks at the context and ignores the text, but it's all part of the unitary.
What do you say is the substantive difference between this pension scheme and loads of others?
I'll come to that. I was just going to take you to paragraph 18, but that's
okay. I'm not in a hurry. Just answer it when you come to it.
My lord, well, all I was going to do is refer you to paragraph 18, which is the corrective construction point which Mr. Short referred you to earlier, and the reference to Chartbrook, which I think I've probably covered and he's probably covered sufficiently already. The circumstances of this particular scheme, two particular features. One is that the scheme was closed from inception. No new members would be joining either many years after inception, which I think was Lord Hodge's example, or indeed at any time after the scheme was opened in 2003, and certainly not after the 2007 rules of the 2008 amendments.
Is that correct? There were no defined contribution actives joining.
Well, certainly, as I recall, it was accepted by everybody below that was the case, and that's the basis on which the judge dealt with it in his judgment.
And why was there a defined contribution option which had not been previously used?
My lord, sitting here at the moment, I can't immediately give you an answer to that, I'm afraid.
Well, maybe the trustees will be able to help with that.
But certainly, as I say, at trial below, there was no issue that this was a closed scheme from inception.
Do you mean the whole scheme was closed, or just the DB sections were closed? Because these rules only applied to DB sections.
That's what I can't immediately remember, my lord, I'm afraid. My apologies. It hasn't been a contentious issue at any stage.
No, I thought I got the impression from somewhere that the DB sections were closed, but the DC section was open, at least for a time. But I may be wrong about that.
Well, certainly anyone who could have been affected by the rules that we are seeking to construe could not have joined after the scheme was established in 2003. I think that is an uncontroversial statement. The second particular feature of this scheme, as again the judge correctly identified, was that members to whom Rule C.2 applied, either in the staff section or the executive section, were by definition those who had transferred as active members having consented to the transfer. And I'll come to the transfer documentation in due course. And in those circumstances, they could easily ascertain the prevailing circumstances when the scheme was established, because they had been sent a number of documents that Mr. Short has shown you some of, and I'll show you some others, in advance of the scheme's establishment, which spelt out in, we say, abundantly clear terms what the prevailing circumstances were. And in those circumstances, the fourth and fifth of the characteristics identified by Lord Hodge essentially did not apply at all to this scheme.
You accept 1, 2 and 3 do.
My lord, yes, I think I must, and certainly it wasn't argued below that they didn't. So, it was 4 and 5 that were particularly focused.
So what's the effect of that? We've got 3 out of 5. So you say what? That we nudge away from textual analysis? Is that the submission?
The submission is that insofar as it is said against me that the full rigour of Lord Hodge's guidance in this passage of his judgment in Bernardo's should have been applied by the judge below, I say that is not right, and the reason it is not right is because the risk of repeating myself yet again, each case, pension scheme case or any other sort of instrument, will turn on the particular circumstances of the instrument and the surrounding context at the time the rule is adopted or re-adopted, and where there are various of the particular distinctive characteristics of pension schemes such as that in issue in Bernardo's that are not present in a particular case, then I say that entitles the judge, as the judge did in this case, to shift the balance of weight to be applied to the various interpretative tools available.
I mean, what troubles me is I'm not sure that the fifth one doesn't apply. And I see that there are no new members, or at least I think no defined benefit members, but members of a pension scheme may not have easy access to expert legal advice. Was there evidence that the members here did?
From memory, there wasn't evidence as to whether they did or did not.
So, I mean, he couldn't legitimately say that didn't apply. I mean, you said there was some stuff that made it able readily to ascertain the circumstances which existed when the scheme was established, but that's, that's actually quite a sort of big ask, isn't it? Because are we talking about 2003 or 1996? Are we talking about 1946? Or, what are we talking about? And they were banned, yes, in 2003. So in that sense, it's not. But it's a bigger point that Lord Hodge is saying, that this is something where pension scheme members are in a worse position than contractual parties generally, because they really are not involved, which applies here.
But, my lord, I don't accept that does apply here. His fifth characteristic, putting the two parts together, members of a pension scheme may not have easy access to expert legal advice or be able readily to ascertain the circumstances which existed when the scheme was established. It's talking, in my submission, of expert legal advice to assist the members to understand what the circumstances were and what the circumstances meant. In the circumstances of this case, they didn't need that because they were sent very clear documents which told them what the circumstances were at the time of the inception of the scheme. And we're not talking about...
They weren't sent the trust deed.
But that they weren't sent the trust deed, they could readily have obtained a copy of the trust deed because they have a statutory right to see it.
Well, that's every pension scheme, isn't it? Yeah.
Can I ask you a different point, Mr. Francis? You've addressed us on the assumption that the only people interested in the construction of this question are the active members. And I understand entirely that the deferreds and the pensioners, and indeed the dependents of active members, are not capital M members, but they are beneficiaries of the scheme and they are affected by the construction of this rule. And Mr. Short, I think, says that he wasn't suggesting the rule meant one thing for one class and one thing for another. Are you suggesting that the rule could mean something different for actives than it means for deferreds and pensioners?
My lord, no.
Well, the deferreds and pensioners, on the evidence we have, the deferreds and pensioners weren't told anything about what they would get under the new scheme. Now, we saw from a recital to one of the transfer deeds that transferring members included deferreds and pensioners who were sent some notice, but we don't have those notices. How can we proceed on the basis that deferreds and pensioners had any detailed information of the type that was given to actives? And they certainly, it's not suggested that they actively consented, because we were told by Mr. Short that it was a non-consensual bulk transfer, which is exactly what one would expect.
My My Lord, yes, that's certainly my understanding from the evidence below. I'm just looking for another document which again deals with the question of providing communication to the deferreds and the pensioners. It is right that we have not been provided with such communications as were sent. It's also right that communication must have been sent. You've already referred to the, yes, here it is, there's mention in the transfer deeds. Can I ask you to look at a supplementary bundle, tab 10, page 203. I'll come back to this in
Thank you.
in context, if I may, but the first page of it is page 200. It's a document that was sent to the trustees of both of the existing plans at that time, October 2002, Six Continents PLC demerger announcement pensions proposals. I'll take you to other passages in due course, but if you turn over to page 203, please. Paragraph 6.3 towards the bottom of that page under the heading Communications, each individual pensioner and deferred pensioner will need to be written to, identifying which plan they will be in the future and the reasons why. The most difficult explanation will be for post-1997 deferreds, and so on. And I don't need to read the rest of that passage. There is also, forgive me just for a moment. I may come back to this again in a different context. In the authorities bundle, may I invite you to turn to tab 32, please?
Just before you leave Mr. Jones's note,
Yep.
6.3 says exactly what I would expect, which is that if you're going to have your pension provided by a different provider, a different scheme, you'll be told that your scheme has moved from the BES or Six Continents scheme to the Britvic scheme. But on the basis you're going to get exactly the same pension, one wouldn't normally expect either the deferreds or pensioners to have to do anything, or to be told in black and white terms what benefits the new scheme will provide, because it will simply say you'll get the same benefits as before. It's going to be provided by a different scheme. The security of your benefits is not affected, and you may be reassured that nothing will change. That's what you would expect that sort of notice to contain. So if I go back to the question, even if you're right that for the actives, Lord Hodge's fifth criterion doesn't apply, because they did have some information, can you say the same about the deferreds and pensioners on the evidence that we have?
One aspect of, well, where I was about to go, my lord, which really deals with the previous point I was making, but just to complete it, it's tab 32 in the bundle.
Thank you.
It's the 1991 Preservation of Benefit Regulations as they were in January 2003. And if you can turn, please, to page, well, 718 is where Regulation 12 starts. It's at the very bottom of the page. Regulation 12, transfer of members' accrued rights without consent. So these are the various requirements and such, the conditions before there can be a transfer, a bulk transfer without consent. The particular point I was going to take you to is at page 720, which is sub-regulation 4B, where it's proposed that a member's accrued rights are to be transferred in accordance with this regulation, information about the proposed transfer, and details of the value of the rights to be transferred, including rights in respect of death and service benefits and survivors' benefits, shall be furnished to the member not less than 1 month before the proposed transfer is due to take place. So there is a statutory obligation to provide them with the information set out in sub-regulation 4B, which includes information about the proposed transfer and details of the value of the rights to be transferred, including rights in respect of death and service benefits and so on. And that goes beyond, we say, simply telling them they're going to be transferred to this new scheme. And two further points on this. One is that, and I'll come back to this probably tomorrow looking at the time. If you go back a page, we're still in Regulation 12. 12.1, a scheme may provide for the members' accrued rights to be transferred to another occupational pension scheme without the members' consent, where the conditions set out in paragraphs 2 and 3 of this regulation are satisfied, and the conditions in paragraph 3, condition rather, is that the relevant actuary certifies to the trustees or managers of the transferring scheme that the transfer credits to be acquired for each member under the receiving scheme are broadly no less favourable than the rights to be transferred. It's what is often referred to as the GN16 certificate. We don't have the actual GN16 certificate for these two transfers. We've got a template in the bundle. That is another another place at which there is a statutory requirement to set out, albeit in the form of the actuary certificate, what the transfer credits are, and certify that they're broadly no less favourable. But the other point I was going to make is this. Mr. Short did not, for understandable reasons, focus on this morning, and he will doubtless accuse me of something to do with dogs and tails and wagging, but the executive scheme had no pension alteration provision. The executive, I can take you to the rules, and I was planning to do that in a little while. So, just to go back to your point, my lord, insofar as one might say, well, normally, if the benefits aren't changing, they're just going to get a letter saying you're moving from scheme A to scheme B. Where one is dealing with the executive members, the new scheme would provide, I think, on the claimant's case, for benefits on a different basis. So it was not moving from one set of rules to a materially identical set of rules. Because on the claimant's case, they accept the executive plan pre-transfer had no power to alter the pension increase rate from 5% double PI. But on their case, there was power, still is power in the Britvic scheme to alter the rate and to lower the rate for executive members as much as for staff members. And that we say is a rather important feature of this case.
Thank you.
May I just touch briefly on what it was the court below was asked to construe? We've touched on this already. The claimant, as it was, kept the focus of this case very narrow. The claim form, as amended, I think 6 days before trial, is at tab 9 of the core bundle. Starts at page 107, but the material bits are at 108. And you'll see that the additions are in red. You'll see that as originally drafted, all it was asking was for the construction of C.10.2 and C.2.2 in the 2007 Trust Deed and Rules. The 2003 rules were added by amendment, as I said, I think it was about 6 days before the hearing. There was a request from our side to expand the proceedings to deal with various, at least some of the many other issues that will need to be resolved in this case, and the trustee, in its studiedly neutral position, did not object, I think is the fair way of putting it, but there was steadfast refusal to expand the case at all. I don't want to take you to it. There's correspondence about it in the bundle. It's supplementary bundle tabs 22 and 23, the last two. But I just note in passing that if the proceedings had been expanded as we had suggested, all of the background evidence in relation to predecessor rules at the time they were adopted and then re-adopted would, we say, have been available. Questions such as the transfer deeds, which Mr. Short urges you to find are not admissible at all, and their construction would probably have been centre stage. But we have none of that. We have none of that material below. But what the court was asked to construe, and what's still the issue before the case, is the two rules, 10.2 and 2.2 as the last question. In each of the versions in which they appear, 2003, 2007, and then as amended the following year, there's been mention of the predecessor rules, but of a different scheme. Those rules were not an issue for the court below, and their construction was not an issue, as the judge, we say, correctly found. You know, I'm sure by now, in the various iterations of the rules, there are general rules. For some reason, they're slightly out of order in the core bundle, but there are staff rules and executive rules. The clue is at the very top right-hand corner of each page. It tells you which bit of the scheme you're in. Each of those contains materially the same rules for our purposes, C.2 and C.2. So you have three iterations. You have two places in each iteration where the rules appear. But, as was noted in the judgment below, if you'll note paragraphs 10 and 41 are two places where this appears, and indeed it's in my learned friend Mr. Short's skeleton for this hearing, paragraph 25. Everybody agreed at all stages, and still do agree, that all of these rules have the same meaning wherever they appear. So in both sections of the Britvic Plan and in all the various iterations from 2003 onwards. And we say that is important because insofar as my learned friend said below, and still says, that one can't use the executive section to wag the dog of the staff section, in my submission that rather misses the point, because if it has been accepted, as it has, that all versions of the rule mean the same thing whenever they were adopted or re-adopted, in my submission it inevitably follows that there's no tail. There's one just has one harmonious, possibly tailless dog. Everything is of a piece. What goes for one set of rules, or one rule in one section, goes for all the others as well. So, for example, insofar as it is said that the transfer deeds are inadmissible because they post-date the 2003 version of the rules, I don't accept that's right. That's the appellant's case. Ultimately, we say that's not of central importance because they clearly predate the 2007 version of the rules. So we're part of the admissible factual background at that point, if not before. So all of these nice points about timing of deeds and so on, ultimately we say don't really matter, because as long as the rules mean the same thing in each iteration, one doesn't need to deal with that as an insurmountable problem. So, having dealt with those introductory matters, let me come to the text and the context. The text, I know you have well in mind. I'm going to take you, if I may, to the versions of the rules in the supplementary bundle. You have the full set of rules there rather than extracts. Tab 4 is probably start tab 4, page 51. Is where the 2003, the first version of the Britvic rules, starts. Perhaps I can invite you to note in passing that these were drafted by Allen and Overy, as indeed were the transfer deeds when we get to look at them. So, insofar as the same identity of draftsman is relevant, then we clearly have that in this case. Again, Mr. Short has taken you to some extent to the rules. Let me do so again in this version. Page 105, please, just to get one's bearings. It has the general rules, and these are part of the DB staff rules. 105 C.2. This is the revaluation provision that's the subject of the last question and the last of Mr. Short's grounds of appeal. And over the page one has C.2.2, the little italic heading deferred pensions. And this is the revaluation rule that is the subject of the last question. And you can see the cross-reference in the second sentence, third line. It's equal to the scale pension increased as from the date pensionable employment ends, as referred to in DB staff rule C.10.2. And 4 needn't concern us. 4 is prorating in the first year. So that's the second of the rules you're being asked. The judge was being asked to construe. And then 113, and just to remind you of the text, C10, bottom of 113 under the heading, bold heading pension increases. And again, we're still, as you see from the top right hand of the page, in the DB staff rules. Each pension under the plan increases in each year after it starts to be paid, except, and then there's a couple of exceptions, and then 2 is the passage, the provision of our focus for these purposes, the part of the pension which exceeds any GMP in payment is increased on the 1st of October in each year, so it's the 1st of October is the payment date. I'll come back to the importance of that in due course. Second sentence, the rate of increase is the percentage increase in the retail prices index. We're not dealing with a defined term here, no capitals, unlike the Kinetic and the Arcadia cases. During the year ending the previous 31st of May, again, that date is significant for reasons I'll come to, but subject to a maximum of 5% of the cap, and then brackets or any other rate decided by the principal employer, which is the key focus for our purposes. So that's the text. Now, the context. I'll take you to the documents in a few moments, but by way of brief introduction, there was a demerger of the 6 continents business, hotels, retail, soft drinks, and so on. The soft drink side of the business was to be demerged. It included a demerger of the pension schemes. And as you know, there were 2 schemes which by 2003 were called the 6 Continents Pension Plan and the 6 Continents Executive Pension Plan. Those schemes, which previously were called BAS, continued after the demerger, and as far as I'm aware, still continue, but were renamed Mitchells and Butlers or N&B. And those are the schemes that are the subject of the High Court trial next month. The Britvic Plan was established specifically to accept transfers from those 2 predecessor schemes, with both active members by consent, deferreds and pensioners by bulk transfer without consent. The way it was engineered was that it was those who were attributable to the soft drink side of the business, if I can put it that way, who were to be the subject of the transfer. And the aim, as we can see from the documentation that I'll come to in a moment, was to transfer relevant liabilities in respect of those members and a corresponding proportion of the assets of predecessor schemes to the Britvic Plan. And as I've said, the whole point of the Britvic Plan, the whole reason it was established in the first place, was to accept those transfers. And that's what the members were told. That is the context, and that's the context in which the members were informed, and that's in fact what happened. The transaction being effected by the execution of the 2003 deed and rules, and 2 transfer deeds, one to effect a transfer from the staff plan, as it were, and one from the executive plan. Now is as good a time as any to have a look at the key background documents, if I may. Supplementary bundles, still tab 10 is where they start. This is, page 200 is the first page of this document. We referred to it a short while ago in the context of member communications, and it's dated 16th of October. Demerger announcement, pensions proposals. I'm not going to read it in any detail. But paragraph 1.2, for example, the existing pension arrangements will have to change for current employees because contributions can't be made other than for a transitional period. Next sentence, the company wishes to provide for a continuation of the defined benefit arrangements to those employees who currently benefit from them. And just note this is sent to the trustees of both of the existing schemes at that point. And 1.5, touching on the point I made a few minutes ago, Britvic accounts for 22% of the total liabilities, 32% of active member liabilities. It would seem appropriate to ensure that its shareholders bear the risk inherent in these liabilities. As I've said, the whole aim was a proportionate transfer of liabilities and assets to the new scheme. Over the page 201, section 2, proposals for new schemes and scheme transfer. 2.1, the company is proposing that there are separate pension arrangements in each of retail hotels, and Britvic replicating the current UK pension benefits with respect to both past and future service. Now, just pausing there, this is another place at which the relevance of the executive scheme rules comes in, because as Mr. Short accepts, the executive scheme had no pension increase, no power to alter the pension increase rate. So insofar as one is referring to executive scheme members, which this document also addressed, replicating their benefits with respect to both past and future service, it could only mean that there would be certainly no power to reduce the rate of pension increase going forward. Page 202, section 4 says much the same, so I won't read more than a few words. New scheme setup is the heading. Third line, in replicating the benefits for members in the new trustee and rules, it's likely there will be the opportunity for streamlining and so on. So it's all saying much of a muchness. 204, section 7, transfer values and company contributions, and this is where the GN16 certificate that I referred to earlier is first mentioned. The actuary will recommend to the trustees assumptions to be used in the valuation of scheme liabilities. Regard will be given to his ability to sign a formal GN16 certificate confirming that members would be no worse off on a transfer. This certificate is required, and so on. In that document, for now, I think we'll leave it there. The next one is tab 11. This one is to the chairman and directors of Britvic Soft Drinks, so what became the principal employer of the Britvic plan. It's dated just over a week later, 24th of October, and it says similar things. Pension scheme changes is the subheading. Paragraph 2, for example, it's been agreed that the existing defined benefit arrangements will continue for those employees who currently benefit from them. Indeed, any new arrangements will ensure that present members of the plans will all have the same benefits for past and future benefits. So again, it's all entirely consistent with the previous document. Tab 12, please, is Page 213 is the start. This is the first of the letters that were sent to active members. This one is the Six Continents Pension Plan rather than the Executive Pension Plan, but there's an equivalent on the next page. 18th of November. In fact, so on my hard copy, the relevant passage has been highlighted, and then when copied, it renders it rather more difficult to read. But the wording is, it's in the penultimate paragraph towards the bottom of the page. The new plan will be set up so that if you transfer your Six Continents Plan benefits to it, the build-up of your pension benefits will be continuous, and when you retire or leave pensionable employment, the new plan will provide benefits for your total period of membership of both plans, which are the same as if you had remained a member of the Six Continents Plan under the current rules. And there was a Q&A document sent with this. It's at 215, a couple of pages on. Again, all entirely consistent. Why should I join the new plan is the second question. This is your only opportunity to join the section, DB section of the new plan that is designed to replicate your Six Continents Plan benefits. Next question, are the benefits in the new plan the same? Yes, and so on. And then there's a more detailed Q&A, which again is entirely consistent with everything I've read so far. Tab 13 is the equivalent for executive plan members, which says nothing materially different, so I don't need to take you to it. I think the next one, for my purposes, tab 15, page 247, and this is one of the key documents in my submission. This is for the pension plan. This is the pension plan version rather than the executive pension plan version, but these are what we are calling the transfer invitations of the 17th of December. You've already received a letter dated the 18th of November from Trevor Jones. We've seen that and so on. And a third paragraph says much the same as we've seen a number of times already. The Britvic plan is being set up to provide the same benefits as currently provided by the Six Continents Plan. These are summarised in the enclosed outline benefits summary. And over the page, we can see why we are calling this the transfer invitation, because that's exactly what it is. Second paragraph, to help you decide what to do about your Six Continents Plan benefits, please read the enclosed questions and answers, and so on. What you need to do now is the next heading. You must complete the enclosed application stroke refusal form. So there's a form, as we'll see in a moment, for whether you want to join the Britvic plan at all, i.e. the consent, and then there's a separate option form to confirm how accrued benefits in the Six Continents Plan should be processed, and a separate beneficiary stroke partner form. Sent with this letter, and again there is the equivalent for the executive plan, was the document that immediately follows the letter in page 249. Again, this was not copied particularly happily, so if I may take you to the executive version, which is in the next tab. It's tab 16. The letter says materially the same things, but one can see from the heading Britvic Pension Plan DB Final Salary Executive section, so this is the executive equivalent. We then have 256, again things have got slightly out of order, but 256 is the do you want to transfer form. 258 is the beneficiaries form, 259 the partner nomination form. May I take you please to 260 though, which is the option form. This is the what do you want to do with your accrued benefits form. And this is for completion. We can see whoever completed this, it's been redacted, but the date was 27th of December 2002. It's addressed to the trustees of the Executive Pension Plan. And then says this: I've read and understood the items enclosed with the letter dated the 17th of December 2002. As we've seen, not only were these forms included with the letter, but the summary of benefits was included. These set out the terms under which the Britvic Pension Plan, Britvic Plan, has offered to provide benefits in respect of my pensionable service under the Six Continents Executive Plan up to 31st of March 2003. They also explain the other options currently available to me in respect of my accrued rights under the Six Continents Executive Plan. And then there's the box with option A, yes, option B, no, I do or don't want to transfer my benefits, my accrued benefits across to the Britvic plan. Over the page, please, again, something that was one of the items enclosed with the letter of the 17th of December, which, as the option form told the members, set out the terms under which the transfer was being offered. And just note 261, paragraph 4, it gets a little circular, but it refers back to the letter of the 17th of December, which again refers to the summary, which is the document that starts at page 263 in the bundle. And Mr. Short has read relevant extracts from this. There's the introductory section, which says who this summary applies to. It is intended as a preliminary announcement summarising the main benefits and contributions of the DB Executive section in the new plan. That benefits and contributions replicate the current terms of the DB section of the Six Continents Plan or Executive Plan, as the case may be. I fully accept that it says it can't include every detail, and that the trustee and rules will set out the full particulars in due course.
Mr. Bryant, I think we're going past 4:15, but I do notice this page, it says the DB section is for new members, so that probably answers one of the questions we had earlier.
Well, it refers to the DB section of the Six Continents Plan rather than the DB section of the Britvic Plan. But yes, well, you're right. Yes, I see the time. May I just refer you to, as Mr. Short did, there are some Q&A documents again at the end which say essentially materially the same things, but really the passages I rely on, perhaps unsurprisingly, are at 264. This is part of the executive section summary, as we can see from the top of this page in landscape. Benefits at normal pension age, it sets out the multiplier for benefits which in the executive scheme is different from the main scheme, the pension plan, the staff plan. There are different categories of accrual rate. We then have pension increases towards the bottom of the page, and as was pointed out earlier, guaranteed increases is the bold heading. Pensions in excess of GMP are guaranteed to be increased each 1st of October in line with the rise in RPI for the year ending 31st of May, preceding the review date up to a maximum of 5%. That, including the dates, ties in with the wording, certainly the initial part of the wording of Rule 10.2 as it became. Then we have discretionary increases. The next bold heading, the trustee and the company currently intend to pay additional increases on the pension in excess of the GMP of 2/3 of the increase in RPI over 5%. These increases are not guaranteed. So guaranteed 5% LPI, intention to continue paying as they had to date, 2/3 of any excess over 5%. Insofar as our RPI exceeded the 5% cap. As I say, there are some further Q&A documents which you may wish to look at, but I'm not going to take you to them at the moment because they say almost exactly the same as the ones we've already looked at. My Lord, you mentioned the time. Do I take that as a
Yes, you do, I'm afraid, Mr. Bryant, yes. How long have you got left, do you think?
In total in my submissions?
Yes.
Um,
Because we've really got to finish by lunchtime tomorrow, that's the point.
that will not be a problem. I can assure
Leaving
you.
time for Mr. Chu and for Mr. Short to reply.
Indeed.
Okay.
Indeed. I think, as Mr. Short said earlier, we'd agreed an indicative timetable, which I'm not sure whether it made its way to you. Mr. Short ran a little over. I will do my best to claw back such time as I can, but we shouldn't be in difficulties.
Well, don't feel too rushed. You can take some of his reply time because he took some of yours. Okay, very good. We'll resume at 10:30 in the morning. Thank you both very much.
Good afternoon.